Welcome to the Turnaround Podcast with your host, Stephen Phillips. In each episode, Stephen speaks to experienced practitioners who discuss their careers, key moments, challenges, and lessons learned in financial turnarounds and business restructuring. Join us as we unravel the secrets to turning struggling businesses into success stories. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, frilibertas.com. Now, here's the host of the Turnaround Podcast, Stephen Phillips.
Welcome to the Turnaround Podcast. In the past few weeks, we've discussed a specific type of debt instrument, the high-yield bond. In this show, we're moving away from one instrument and focusing on distressed debt companies, or distressed companies, I should say, and how such companies may be assisted with more formal insolvency and corporate procedures. I wanted to speak to somebody who is a licensed insolvency practitioner here in the UK to gain some practical insights into the tools and procedures used to turn companies around. I'm delighted to be joined by Lisa Rickelton, a Senior Managing Director of FTI Consulting. Lisa has more than 20 years of insolvency and restructuring experience, advising stakeholders across a number of sectors. Lisa specializes in contingency planning, insolvency solutions, and insolvency outcome analysis and entity priority models. Her experience includes many cross-border situations. Most recently, Lisa was involved in undertaking a comparator analysis in the Adler restructuring plan, and I'm sure we'll return to this in more detail. Lisa, welcome to the Turnaround Podcast.
Thanks, Stephen. Thank you for having me on, and thanks for the kind introduction.
Well, Lisa, I wanted to start in a very simple way, which is when you talk to people outside of the industry in the pub or in a dinner party or something, how do you describe what you do?
Sure. So I think my answer's probably developed over time as the role has evolved over time. But certainly earlier in my career, I would be talking about being out on site at trading and administrations, trading insolvencies, where we're effectively running the business for a period of time to try to achieve a sale of the business. And with that, ideally try to save jobs as well. And I always made reference to that latter point, partly because I think, it is a part of the job that was always important to me. That sort of social conscience side of things and it having a wider meaning, not purely financial.
Of course.
But also one of my friends that I trained with, he was in the tax department, and he would always, at dinner parties, try and answer that question for me. And he would always say, Lisa makes people redundant for a living. So I'd kind of step and say, actually, a big part of the job is trying to avoid that. And I think I would also talk about, when you're an administrator or liquidator of the business, around the fact you become responsible for really everything to do with the business and take on the role of directors. So it can be quite a broad role in many respects as well. But certainly as the roles evolved, I think my kind of description of it has evolved. So I would now talk more about, pre-appointment involvement and the more restructuring related aspects of the role. So, I would say that I take insolvency appointments, but actually a lot of the work is around working with companies or lenders to distress companies to try to figure out ways in which they might avoid an insolvency.
Yes. Yeah. Well, I ask all my guests the same question, which is how did they get started? So how did you get started, Lisa?
Yeah, sure. So I think it's probably fair to say that, most students don't really know much about being an insolvency practitioner, and most of us have ended up in the profession sort of accidentally at some point or another, and that's certainly the case for me. So when I was actually, the story starts quite early for me. When I was doing my A-levels, I was looking to try and get onto a scholarship program that was run by Arthur Andersen, and you worked for a year before uni, and then went off to university and worked in the summer holidays with them as well. So in the recruitment process, somebody from their HR team had decided that I would be suited to the corporate recovery team, as it was called then.
Yeah.
I didn't really know much about what this involved, but very soon I was quite happy with the decision. To me, it seemed much more interesting and very hands-on compared to audit or tax, which most of the other people were doing on that program. And it was really hands-on from day one. So just to give you an idea, I think literally in the first week of the role, I was going out to the insolvency of a haulage company. It was a relatively small company, but we arrived on site. There was myself and a couple of senior colleagues, and they both went into a meeting with the directors to talk about the strategy and potential buyers for the business. And just before they went in the meeting, I was told, well, the fuel cards have been cancelled and the trucks are out delivering and they need fuel. So can you, get some fuel organized? And they're all around the country, these trucks. And, I didn't really know what I was supposed to do, but, literally just, brand new out of school, and picked up the yellow pages and got on the phones and tried to figure it out and managed to get that set up. And that sort of practical problem solving aspect of it, I did enjoy from the beginning.
Yeah, a little bit different from being in the audit department, I would have thought.
Yeah,
I think you've alluded to this in your earlier comments, which was I wanted to ask you a little bit about how it's changed over time. So I guess what I would get from that is you were doing operational administrations of small UK companies when you first started. So what has changed in terms of your role?
Yeah, so the role changed gradually over time. So when I first came back into the Arthur Andersen team after university, the role then was very similar to what I'd done in that initial period. As you say, kind of UK trading, insolvencies largely. And then Andersen's collapsed, which was probably, although quite sort of nerve-wracking at the time, it was probably quite a good experience for a person working in insolvency at the early stages of their career to sort of see that happening and develop real empathy for the people who are in these situations. So then we worked, the whole team moved over to EY, and I worked on a wide range of projects there. I was there for 6 years. And at that time, I was starting to see a little bit more in relation to some cross-border work. Started to see more gradually, probably, I think, initially from about 2006, seeing pre-packaged administrations. And then also in the final year that I had at EY, I was working on the Metronet public-private partnership administration. So that was the business that ran the infrastructure for a significant proportion of London Underground. So sort of starting to see some of those larger projects, both UK and cross-border. And then that continued when I moved to FTI Consulting in 2008. So at that stage, FTI was a real sort of startup business in London, but backed by a hugely successful US restructuring practice. So then we were working on some transactions with US colleagues, and that cross-border side continued to increase over time. And then more recently, the role has also included work on schemes of arrangement and restructuring plans, and doing that comparator role, or the relevant alternative analysis of what would happen if the restructuring wasn't complete. And really, I think there was other stages in between. So, pre-packs continued, and then also looking to see where we could use insolvency as a tool, which didn't have as much uncertainty for the whole business. So more looking at holding company insolvencies where that was appropriate, to try to avoid the whole group being in an insolvency process. So it's definitely evolved a lot over time with different use of different tools and new tools.
Well, I guess thinking about holding company insolvencies, that's probably something we've been seeing a lot more of over the last sort of 10 plus years as the private equity industry has taken control of so many different businesses, because in those situations you've got different debts in different boxes and the operational companies are quite low down, and so you can probably do quite a lot of restructuring of the debt higher up in the structure without having to put the main operating company into an insolvency. I suppose that's been your role, which I've seen in a number of situations. But you talked about pre-pack insolvencies, and they've often been in the news. You often see sort of restaurateurs often criticised for leaving their suppliers in the lurch, etc. Do you want to? Can you just sort of describe a little bit about how you see a pre-packed insolvency and what's involved?
Yeah, sure. So sort of start with just an explanation of what it is really. So it's where the sale is negotiated in advance of the insolvency appointment, and then the sale documentation is signed by the administrator once the insolvency appointment takes effect. And there might have been often a sales process in advance of that and before the insolvency, but that's not always the case. So sometimes the insolvency practitioner may be relying on valuation evidence to ensure that they're achieving the best price possible in the circumstances of the insolvency, because that's an important sort of criteria in terms of fulfilling our statutory duties.
Yes.
And I think there's quite a few advantages really of a prepackaged administration. So it avoids that disruption and uncertainty that you get at the business when you have a trading insolvency. Trading insolvencies can be quite value destructive. There's a lot of uncertainty for employees, for suppliers, and often businesses can deteriorate in an insolvency. Not all.
Well, I guess the key point. Sorry, it's the key point. It's public, isn't it? That you've gone in and that has a sort of it has a negative connotation, even though obviously you're doing your best to turn the business around or do the best for your creditors. So what I get from this is that it's often the management who behind the scenes are affecting many of the aspects of the sale or beginning to sort of do the sales process, and then you come in pretty much at the end of the process, but at the same time you've got to be certain that the best price reasonably obtainable has actually occurred, and it's not some kind of sweetheart sale. How do you get comfortable that you can that when you're appointed that you can immediately sell the business?
Yeah, so it varies really in terms of the extent of our involvement before the administration appointment. Sometimes it can be a situation where a sales process was being run and it was hoped that the value from the sale process would be sufficient to actually conclude the deal solvently, and then that's obviously not transpired, and they need to get an insolvency practitioner involved to review the process and get up to speed. Whereas other times you are in a situation where that's been anticipated from the start, and we are, we might be running the sale process within our firm, or it could be that an investment bank is running the sale process and we're monitoring it all the way through. So that's often the case. Where there's a valuation, then that's something that we would initiate. We would ensure that an independent valuer was appointed to undertake the valuation work. In the same way that on the sale process we would feed into understanding who the buyer list was, and what was the time period available to those buyers? Was there good information available? To review that whole process and review what's possible as well. What's the liquidity runway in which to sell this, and what's the other option? So if you were to go into administration and not consummate that transaction, what do we think would happen then? And are we getting best value? And that can depend on, the nature of the business, whether there's funding available for an insolvency. As I mentioned earlier, some businesses just don't trade as well in insolvency. For example, the people business, so if you've got a firm of a business we were involved in about 10, 15 years ago, it was a nationwide firm of accountants. And, it's a business which is entirely reliant on its people. And if small teams want to sort of just, take themselves off to other competitor firms, they're able to negotiate that quite quickly and without any actual value to the business which is facing administration or has gone into administration. So in that case, kind of holding things together beforehand and getting a solution lined up, ready to go. In that case, there wasn't a buyer for the business as a whole, but there was different buyers for different parts of the business, and we completed 6 separate pre-packaged transactions on the day of appointment. And so that was, I think, to me, a success. If we hadn't have used a pre-pack there, the whole thing, I think, would have disintegrated. So I think it's a good example of where a pre-pack can really add value and avoid that uncertainty and negative publicity that you mentioned.
How there have been criticisms, how have they been addressed by the profession and statute and generally how have things changed?
Yeah, sure. So, look, as you say, I think there has always been some criticism, partly because the process is less public. Stakeholders are concerned, perhaps, that the buyer might be a connected party. For example, if it's an owner-managed business and they're the ones buying it back, I think there can be an additional level of concern from stakeholders.
Yeah.
The stakeholders who are being wiped out, but they're seeing the owner-manager continue on with the business under a new name. And they might be concerned that the transaction was at a low value and were there better options available or not. So as a profession, we're very heavily regulated. So all insolvency practitioners have regulators, and the regulators in the profession have worked together to sort of address those criticisms. And one of the main things that has developed is, so we have statements of insolvency practice, which are guidelines and criteria that we have to follow when we undertake our insolvency work. And then known as SIPs. One of the SIPs is SIP 16, and that's entirely dedicated to pre-packs and these concerns and trying to address them. And the requirements of SIP 16 have evolved over time. There's been a few different versions of it every few years. There's been additions and improvements to it to continue to seek to address these criticisms. There's a few different aspects of it. So one is around kind of the best practice guidance and, in terms of who you're advising at what time, in what capacity. And so that's sort of more general best practice advice to the insolvency practitioners. But there's also some very specific advice around, the marketing process, for example, that might be needed. There's very specific requirements around disclosure. So we have to produce what's called the SIP 16 report, which is part of our reporting to creditors. And that has to be quite extensive in terms of outlining what the other options were that have been considered, what any other offers were for the business, the detail of the transaction that's been concluded, including the detail of how consideration has been allocated to different assets, because that can influence which creditors might be able to access that value.
Yes.
In the case of secured creditors or priority claims. And then, more recently, there's then been brought in as an evaluator report where there's an independent professional is engaged to review the proposed transaction and opine on it. And, that is a requirement where there's a connected party transaction. And they would also, as well as looking at the transaction, usually be asked to look at the viability of the business going forward. So what's going to happen differently this time to give the creditors some sort of assurance that the business is viable and can continue to trade in the new company. So there's been quite a lot that's been done, and there's been independent reports to support the different rules that have been brought in, and I hope it is helping to address the criticisms, because when it's used properly with proper diligence and assessment of the options, then really it is something that I think can help preserve value and be a good tool for the profession to use.
Yeah, I'm very pro pre-packs for the very reason we discussed, which is the publicity and the possibility of employees walking out the door and other suppliers just sort of getting put off, etc. If you can negotiate a good sales process behind the scenes and then execute at the last minute, that's going to be good to retain value. So I wanted to also talk about other tools that you're using, and it feels to me like pre-packs are one of the tools in the armory, and one probably used almost one of the sort of mainly used tools. But for larger businesses, there are restructurings, there are schemes, there are, CVAs. Maybe talk about how you've seen those used in your practice.
Yeah, sure. So I guess often with the tools that we see, often the tool themselves have been around for a very long period of time, other than restructuring plans. But over my career, the use of the tools has developed. So as we talked about earlier, pre-packs becoming more common. A pre-pack administration is not a separate tool. The administration is the tool, but it's used in achieving a pre-pack. So that's not governed by the legislation. And we saw the same thing evolve over the last 20 or so years in relation to CVAs. So CVAs as a tool have been around for a long time. But I think, perhaps 15 years or so ago, we started seeing them used significantly in relation to leasehold restructurings. So typically retailers, hospitality companies. So, the tools get adopted for different techniques as the market evolves. But essentially, CVAs have been around as a long time as a method of effectively agreeing a compromise with creditors outside of a formal insolvency, and that's in a way slightly similar to what a scheme and a restructuring plan try to do. They're in court processes in the way that a CVA isn't. And the other key difference is that they're both Companies Act procedures, scheme of arrangement and restructuring plan. And so that, I think, as you say, can be quite attractive to larger companies where, the tool can be more suited to what they're trying to achieve often, in so much that it's often a debt restructuring rather than a operational problem. So that's certainly an area where we've seen increasing work over a number of years now, but more recently in relation to restructuring plans, which came in 2020.
And I certainly think it's quite an easy sell to international companies often to be able to say, oh, this is a Companies Act procedure. It's not an insolvency procedure. It doesn't quite have the same sort of shock value that you're going down. We're going into an insolvency process. So I can definitely see the attraction on for schemes and restructuring plans. I'm just trying to sort of work out when you would use a CVA, when you would use a scheme, when you would use a restructuring plan. What is your sort of, how do you game that particular process?
Yeah, sure. So, look, I think, perhaps even taking into account a broader options as well. I think, it's always important to start with sort of understanding the situation that's facing the company, and that can be quite wide ranging, and not every situation needs a formal tool. Sometimes a consensual restructuring can be the right answer, and certainly if it's achievable, often would be the right answer. But the situations facing distressed companies can vary quite significantly. So we see situations where perhaps the company just needs some short-term forbearance or liquidity support, or other situations where the underlying business is viable, but the company can't sustain its current debt. And other situations where the business is underperforming, or the business model in its entirety just doesn't really work anymore. So understanding that is often pretty important to understanding the relevant tool. So, for example, a scheme of arrangement isn't going to help you if you have a lot of operational liabilities at a lot of operating companies around the group, because a scheme of arrangement is usually targeted at, holding companies or the key debt issuing companies, much more targeted tool. Whereas a CVA or an administration could be something where you could deploy that if there's challenges around the group as a whole. And then, for example, in an administration, it's possible to pick and choose the parts of the business that are viable, and sell those to a new co. And then if there's parts of the business which just aren't viable anymore, then those businesses can be wound down in an orderly way through the administration process. So that, I guess, that hopefully gives a little bit of a feel for understanding and how we think about that.
I suppose I think that often if you're going to use a sort of a scheme or a restructuring plan, the business has probably got to have a certain size to justify the sort of the legal cost. So that there's one thing. I think other things that you're probably thinking about are, is this a secured debt? In which case, you probably can't use a CVA, but you might be able to use a scheme. And I think the other thing about restructuring plans that we should sort of, remind the audience is this cross-class cram down, and we'll talk about that in a minute. But obviously that's a new kind of feature that has been pretty sort of helpful. But before we get into that, I wanted to talk to you about, often you're brought in, with a sort of view to being a sort of plan B. There might be a consensual restructuring that's proposed, but behind the scenes, Lisa Rickelton is, providing the plan B. So I want to understand what's that about, and really about the psychology of that, and what this plan B and plan C is all about, that restructuring people are always going on about.
Yeah. So, I think essentially, plan A is often a consensual restructuring. And it's often really important for many of the stakeholders that there is a plan B as a contingency plan. And there's a number of reasons for that, or a number of different drivers from different parties. So lenders will always want to be able to still maximize recoveries if plan A fails. So having a contingency plan ready to go provides that sort of assurance. But then with a director's hat on, they should be conscious of their director's duties and wanting to act in the best interest of creditors. So with that in mind, if they feel that plan A, might not be successful as a prospect of that, then they might want to also be thinking about, well, what's the plan B? Is there a contingency here? And it can also, having a sort of ready to go contingency plan or a well-developed contingency plan can also be really important to help achieve plan A, keep everyone focused on that. It acts, as perhaps a stick or a threat for people to really focus on plan A. And often there could be more than one plan B. It often, as you say, goes down a sort of a waterfall of options. And so maybe there's a plan B, which is a pre-pack of a holding company and the sale of the shares in the rest of the group, or plan C might be a wider group-wide insolvency, but still with planning as to how there can be a soft landing for that and recoveries maximized as much as possible.
Yeah. Let's move on a little bit into perhaps a slightly sadder aspect of the business, which is pursuing directors. So we talked about the fact that if you go in as an administrator, you presumably you have to look at the actions of the directors prior to the appointment. In what circumstances do IPs decide, okay, I need to pursue this? Or what are the kind of red flags for you when you go in and you look at directors' conduct?
Yeah, sure. So I guess there's a couple of initial investigation sort of areas that are just necessary, regardless of whether we think there is anything to go after there. So there is a requirement to, as an insolvency practitioner, to consider all of the assets that might be available. And so that would include whether there's potential recovery actions that could be brought. And there's also a requirement to report to the insolvency service on director conduct, and the consequences there being around perhaps directors being banned from being able to act as directors for a period of time. So there's some initial level of work that we need to do on all of our cases, and then to the extent that that brings up anything which raises concerns and questions, then clearly there's a further level of analysis needed to understand that. So the sorts of things that can be an issue sort of broadly in terms of types of actions would be transactions that undervalue, transactions that defrauded creditors, or more general sort of misfeasance. And often it's sort of apparent fairly early on as to whether or not there might be some prospect. And so where that's the case, you would always approach it in stages, and at each stage sort of assess the cost benefit of doing that together with whoever's funding the investigation work. So for example, if the action is against directors, do they have substantial assets, or is there a D&O policy that would likely respond to the sorts of issues that we're talking about? Considering that up front, the sort of pragmatic aspects of it are always something that we do. And then, we work with our colleagues internally who are forensic experts or data discovery experts, where there's a more sort of full-blown investigation, but regularly reporting to secured lenders or whoever the funding party is, to sort of assess that cost benefit all the way through. And there's many times I've been involved in these situations where I think ultimately there hasn't been a clear cost benefit, but there's been other actions that we can cooperate with. So the insolvency service actions, or for example, the Financial Conduct Authority. There's been cases I've been involved in where they've been looking to bring their own actions, and so we're cooperating with them at a level which is significantly less cost to perhaps the secured creditors than bringing their own recovery action in full.
Yeah. I have to say, it's a part of my practice that I have increasingly been focusing on, not necessarily defending directors in after the event. It's more in a tricky situation, a stressed company, plans are being made, and it's useful, I think, to come in as an independent counsel and say to the directors, here are the do's and don'ts. Here's the memo. These are the things you need to avoid. These are your duties at the moment, and how duties shift as the company, might head towards what we call the zone of insolvency. And I think that's a sort of separate, whole separate discussion. But I think it's certainly something that I've really majored on, and what I have noticed in a way that what happens is, particularly if you go in as a liquidator, the director is a bit shell shocked, talks to the liquidator, splurges out all the things that have happened, and before you know it, that liquidator is using these these confessions, as it were, against the director. So it's important to get some advice early doors, before disaster hits, is all I'm going to say. That there's a whole separate discussion about that.
Yes, I'm sure there is, and I agree with that. I think we often see that sort of situation where there's legal advice for the company, but there's a point at which the directors need to have their own legal advice as well. And I think often directors don't necessarily appreciate the beginning, the fact that that's two different hats. But I think once they start getting that independent advice for them, they sort of really start to understand and see the benefit of that, and the separation of the roles.
Well, I think the other thing I see is portfolio companies of a private equity house have directors. The directors are often used to listening very carefully to, effectively their bosses, the private equity house. Then actually when things get stressed, that's when the board suddenly has to realize they are a board of directors. They perhaps, of course, they would be listening to the PE house, but they don't necessarily have to be following all the instructions. And I think it's also useful for the PE house itself to have to make sure that the board itself is appropriately, taking advice. But let's move on a little bit to where you've had a role for foreign companies, which I presume is mainly it's in schemes and in this newfangled restructuring plan that we've just had. I presume you've seen a lot of that kind of work.
Yeah, that's right. I mean, I think, there's always been an element of cross-border work sort of in addition to that, including sort of joint appointments with colleagues overseas, for example, in Cayman or Dubai. And, sort of large international situations where perhaps, holding companies are based in the UK. But as you say, I think in terms of, restructuring of foreign companies, probably the majority of my experience there has been in relation to schemes and restructuring plans, where, I think companies have been looking to use the UK tools to restructure their debt.
Yes. Yeah. And tell me a little about, if you can, your role in Adler, because that was a very sort of hot topic, and the restructuring occurred via a restructuring plan. How were you involved?
Yeah, sure. So Adler is a German real estate group, and in the case of Adler, so various different foreign companies use different techniques to create sufficient connection with the UK to use a restructuring plan or a scheme. And in in the case of Adler, that was an issuer substitution. So an English company was the issuer substitution entity. And we were instructed on Adler by the 2029 note holders, which was the most later dated of all of the series of notes that Adler had issued. And there was a restructuring proposal that they'd seen, and the company had tried to implement that using a process in Germany, well, in relation to the bonds, which was a consent process, but that failed. And as a result of that, we're then looking to use a UK restructuring plan. So the ad hoc group of the 2029s were aware of the nature of the proposal before they came to the UK courts, because they'd sort of tried it through that earlier process. And we got involved, and my role really ramped up once the UK restructuring plan was announced. And the AHG of the 2029s wanted to challenge the plan. There was a number of different aspects in which they challenged it. But my role was really very much focused about the analysis of what would the recoveries be under the proposed restructuring plan versus what would the outcomes be under the relevant alternative. And that all goes to the sort of the no worse off test, that creditors have to be no worse off. And we worked with Knight Frank in Germany, who undertook some valuation analysis. We spent a lot of time reviewing the company's evidence on their relevant alternative and doing analysis on that. And then, we presented a report which was submitted along with the challenge, and that was Part 35 sort of expert witness report. And that covered a whole range of aspects. But I think, one of the key points that we sought to bring out was the fact that, it was far from guaranteed that in the restructuring plan, 2029s would get paid out in full, which was the company's case. And then I was cross-examined in court as part of the sanction hearing, along with the valuer and various sort of German law restructuring experts as well. So it was a good few days worth of cross-examination. But ultimately, the company was successful. But following that, the group, the HG of the 2029s, sought to bring the case to the Court of Appeal, and then ultimately won the Court of Appeal application, was successful there. And I think the crux of that was really in relation to sort of the points around pari passu. So the fact that actually these various different series of notes on an insolvency would all rank equally, but under the restructuring plan, the 2029 notes remained with that longer dated maturity in a restructuring plan, which would have not necessarily led to them being paid out in full, but the earlier series of notes would have had more chance of being paid out in full. So that was the kind of crux of the appeal.
Yes. Great. Well, I guess when we were preparing this, one of the issues I said is in the past, it felt like schemes were very kind of, you could have a certain amount of certainty about whether they can be implemented. And I guess one of the things about having this cross-class cram down that I talked about earlier, in other words, the ability to, for certain creditors to be crammed down in a restructuring plan, probably means there's going to be a lot more of this, more contention and more arguments, more litigation, and that probably does inevitably mean a little less certainty. Do you agree?
Yeah, I think so, to an extent. I mean, I think there's some aspects in which I think the Court of Appeal judgment on Adler is helpful, provides guidance and clarity around some aspects. I think, as we talked about earlier, when, the touched on some of the high level aspects around weighing up tools, and clearly, that goes into significant more depth on a project, and that I think will continue to be the case. And restructuring plans are one of the options, and the pros and cons will need to be assessed, and that has to include the risk of challenge in the same way that CVA, there's challenge risk. There's a 28-day period after the CVA. People always had to factor in, there would be a risk.
Yes.
So that risk on a restructuring plan, could be compared against perhaps an enforcement where, the transaction happens immediately, and the challenge risk is after the event. And perhaps, in a restructuring plan, in most instances, you'll know where you're going to get to by the time you've got to the end of the sanction hearing or got the sanction hearing judgment. I think the Court of Appeal probably would still be a rarity, but that challenge in the period leading up to the sanction hearing and at the sanction hearing, I think will continue to be a risk of sort of slight delay to the process and additional cost to the process. And I think with the strength of the tool and having cross-class cram down, I think that's inevitable that will be there to a certain extent.
Yeah. Well, it's certainly, to me, it has fixed an issue that you saw in schemes for many years, which is the scheme really only related to the debt that the scheme focused on, and it couldn't really touch on other debts or the equity or anything like this. So having a restructuring plan where other classes can be effectively crammed down, even if they vote against, is undoubtedly a good thing. But it, as discussed, it probably is going to lead to some more litigation. I wanted to move on. We're close to the end, and so I wanted to ask you a question of which deals or deal you have been most proud of being involved in.
Yeah, sure. So I guess it's probably not something I really think about in that context exactly, but I think I'm certainly the ones I remember well, often ones where there's some sort of milestone that can sometimes be a market milestone, something new, but often it can just be a personal one. The first time I've done something like on Adler, first time being cross-examined is obviously quite a memorable point, and being involved in a case that's gone to the Court of Appeal. But I think often the sort of memorable ones will be situations where there's actually quite a significant challenge that's facing the company, where no one really expected anything positive to be able to come out of it, but we were able to ultimately salvage some positive outcome. So I think so an example of that might be from a few years ago would be Polarcus, which was a Cayman holding company, and I, together with colleagues based in Cayman, were appointed as the joint provisional liquidators of the company. And it was a business that operated providing services to the oil and gas sector, doing seismic surveys. And clearly the vessels were a very important component of being able to operate that business. And we were brought in to help the company a few days after their banks had enforced over the majority of the vessels that they operated from, or vessel owning entities. And so suddenly they had no, other than one, they had no vessels and aren't really able to manage their business anymore. So it kind of seemed a pretty dire situation. And there was also a lot of contagion between the vessel owning entities that had been enforced over and the rest of the group. So intercompanies, employees employed by one entity, but working on the vessels that were owned by other entities and now sort of under the control of the banks. So it's quite a difficult situation. And there was another vessel which was financed by bondholder debt, and we were able over a period of time to work with management to ultimately sort of enter into a transaction which allowed them to build a new business around that remaining vessel and build a business from there, and included sort of chartering some new vessels to supplement that. They could run that business and identifying which contracts in the group could be salvaged. We're in entities that were clean enough that they could continue to operate those. It also involved quite a lot of negotiation with the banks who'd enforced, and working with them to sort of achieve that separation in a way that was sort of acceptable and viable to all parties. So it was quite a difficult situation where ultimately, a good proportion of the group was able to survive. There were still, a number of liquidations around different jurisdictions. But something positive was able to come out of it. They were able to continue to survive in a form. And it was also one where we got to work with colleagues across a lot of jurisdictions to be able to deliver that as well. So that kind of felt like something we could, be proud of being part of that. So I think stories like that where you think this is going to be really difficult to salvage anything from, and everyone works together, including, the company and their other advisors all work, incredibly hard on this to all come together to get to that solution.
Yeah, and I think in a way that's the type of story that I was alluding to with the title of the podcast, really, the turnaround. The fact is that usually you come in an absolute mess, and hopefully you exit with something that is emerged from the disaster. So well done on that. So final question really is just, are you busy at the moment? Is FTI doing lots of stuff? We're in an interest rate kind of point where things perhaps the interest rate may go down. But how do you see business in the next few months?
Sure. So I think it's quite a large team that we have, and so there's quite a bit going on in terms of some interesting projects and roles. But I wouldn't say that across the whole team that we're flat out right now. It feels that the market is still sort of a little bit patchy at times, and has been for a little while. Talking to others in the market, I think that in terms of the insolvency side of things, we're seeing through the stats and the market, some of the smaller insolvencies really starting to increase over recent year or so. And again, at the sort of smaller end of the market, a lot of that's been driven by more winding up petitions. And, suppliers and HMRC, being more proactive around that sort of situation. And in terms of sectors, I think, particularly colleagues who are focused more on the mid-market side of things, they're seeing a lot of work continuing around the retail and hospitality side, as well as, we're all seeing that in the market more broadly. So consumer spending continues to be under pressure. And then, businesses are facing, there's been recent further increases in minimum wage and business rates. So there's still a lot of headwinds facing those smaller businesses, and we're starting to see, more and more challenge there. I think in some of the larger and international businesses, it's a bit more sector specific, and also jurisdiction as well. So, our team in Germany has been flat out for, well over 18 months. And I think that's true of everyone working in the German market. And we've seen some of that here, Adler, Aggregate, Plus Server, all German cases that, myself and the UK team have been involved in. And real estate, both Germany and the UK and beyond, that's a sector which we've been seeing seeing increasing levels of work in over the last year or so, and that we just see that continuing.
Yes.
So I think that there's certainly a reasonable amount of activity, but it's sort of, I think in some of the larger companies, still to hit really, there's less early warning on covenants, and it's more sort of liquidity events that are going to drive the issues. And so it's sort of sometimes becoming later and later that they're really coming to the fore.
Yeah. Well, I think if you're a private equity investor listening into this, I'd hope that you'd understand that it takes quite a long time to do the kind of restructurings that we've been talking about. And even if you've got loose covenants and you don't actually have a default that you're facing, it takes time. So you need to sort of get going now. So I expect there's probably a fair amount of paddling under the water that's going on across the city and worldwide, given the interest rate environment. But I've taken far too much of your time. Hopefully, people listening to this will have got some understanding of what you do. It's been really good to talk to you, Lisa, and good luck in the next few months as we go through this cycle. Thank you.
Thanks, Stephen, and thanks again for inviting me on the podcast.
Thanks. Bye.
You've been tuning in to the Turnaround Podcast with your host, Stephen Phillips. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, freilibertas.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.